special video here. We are with Piia Paula Tarvis from Labour Inspectorate, who will enlighten all of us about most things labor regulations in Estonia. Thank you so much for being here with us, Piia Paula.
You're welcome, and I thank you for inviting me. So I am Piia. I am a counseling lawyer, meaning that whenever both the employers and the employees have issues in their or just questions that they want a clarification on, I am the one who responds to that via emails or via phone calls. So it's there are a lot of questions coming from people. Sometimes there are things that I have never even thought about, but that is what makes my job interesting, that that there are so many different questions in this world. So I learn something new every day.
That's wonderful. So let's start with the questions, right? So we have the most frequent asked questions. So let's start with the questions. Here we have some of the most asked questions to us, and let's start with the first one. What are the main labor laws and regulations that I should be aware of when hiring employees in Estonia, Piia Paula?
So the most central act is the Employment Contracts Act, which regulates all the employment relations, work and rest time, different holidays, leaves, rules of termination, employers' liability in case they do not follow the rules that are stipulated by the laws. So let's say Labour Inspectorate checks whether you have concluded written contracts with your employees, and then when the employer hasn't, then if the employer is liable for that in that question, and Labour Inspectorate can take measures against that.
Cool. And another question related to that. Are there some mistakes when people are thinking, like when they're hiring someone in Estonia? Like, do you have on the top of your mind some mistakes that employers do, especially newbie employers?
Yes, well, it's important to state all the important information in the employment contract. So both the employer and the employee have the information in writing what that contract includes. So let's say work duties. So it's really important that both parties understand what they are. So in case there is a dispute, there is clarity in that question. Also, what I wanted to clarify is that another very important regulation is the Occupational Health and Safety Act, which sets all the safety and occupational health requirements and both the rights and obligations of both the parties, so employer and the employee, in creating and ensuring the healthy working environment, and that act also sets the liability for violation of those requirements. And also, it is important to note that the law of obligations and act on the general part of the civil code also apply to labor relations, and also, of course, Equal Treatment Act and Gender Equality Act.
Interesting. Yeah, that's for sure, because when we think about global founders, we are talking about a founder from one country hiring people from another country, and the company is in Estonia. So everybody should be aware about what we are talking about here in this contract, and making sure that everybody understands and have the same concept of what the employer and employee are talking about. Because sometimes, because of the background of each person, people they have a different perspective on what, I don't know, some labor regulations or standard labor regulations mean, right? So that's why you are so important here for us. What are the typical employment contracts used here in Estonia, and what do you think what should be included in them?
So like 99.9% of the time, I would say, so in most cases, work is performed under an employment contract. However, on the basis of the nature of the work, it is also possible to conclude another types of contracts. So let's say a contract for services or an authorization agreement, but those are not regulated by the Employment Contracts Act, but the Law of Obligations Act. So that means that under these aforementioned contract types, the person doing the work is kind of like a professional. They are not subject to the control and management of the employer, but they are independent professionals. So that the employer cannot set the time or the place or the method of their work. So before choosing and signing any particular type of contract, it is really important to consider which type actually applies and which is the most suitable. So in order to differentiate which type of contract is applicable, first it's necessary to establish what is the aim of the contract. So let's say if the objective is to regulate like a certain assignment, let's say I'm going to perform a concert or give a lecture. Like we could say right now that I am giving more or less of a lecture. So this could be a contract of services, or also like writing an article, or like it's a similar independent action. So that's a contract of services, or so I can choose whatever, like the way how I am doing that the job. But if the aim is to produce or alter something, then that's an authorization agreement. So for example, I ask someone to sew my blouse, or I ask someone to install a door to my office, or I don't know, paint the walls another color than this white one. So that could be an authorization agreement. So I ask someone to come, and they are doing a solo, meaning that they choose how and when they do it. But employment contract has really specific characteristics that differentiates that type of contract from other types. So that, as I mentioned, the employee is being subject to the control and management of the employer. So I am an employee, I come to the office, work my 8 to 4, and my employer controls how I do my work, more or less. And then I have to do my work personally. So I can't send my sister here to talk to, or do my work instead of me. Also that an employee gets paid periodically. So meaning like once a month at least. And working in the office, and I am subject to the rules of work organization set by my employer. So let's say I have to, look proper, be polite to my colleagues, everything that my employer has set how work goes in our organization. And it's important to note that when choosing the type of contract, sometimes a wrong type of contract is chosen. So, but the Employment Contracts Act assumes that when a person works for another person, and it is assumed that this work is usually paid or remunerated. So then the law assumes that there is an employment contractual relationship, meaning that in case of a dispute, when there is another type of contract that was concluded, then the employer has to prove why it is not, in fact, an employment contract, but another kind of type of contract. So that is an important thing to note. The second part of the question was what should be included in the contract. So I think it would be wise for me not to read it out loud, but I hope we can project it somewhere here or here, so there are like at least 14 necessary things that must be included. So I don't know, the name of the employee and such. So working time, description of duties, but I hope we can project them somewhere near me.
Yes, we will. This matter, it's so important because it's so wise to protect not only the company, but the employee. The employee is the person who will make your company shine after all. So a good contract is more than an obligation to protect this employee. So I see many global founders, many people, especially those who are starting, they tend, for instance, to not do well this transition between the freelancer and a hired employee. So this is when labor regulation play, and I think it's important for founders to understand that's crucial to talk to a consultant from a labor inspectorate like Piia Paula, or a lawyer, to understand what sort of contract it is the best one to apply in some certain situations and employment situations, right? So this is a topic that's very sensitive, and everybody should be very, very careful with it, especially protecting your future employee, right? So let's talk about working hours. If someone is hired then under Estonian contract, what is the normal and usual working hours here in Estonia?
So full-time work is 40 hours per week or 8 hours per day over a 7-day period. But it is also possible for the employer and the employee to agree upon a shorter working time. So that means part-time work, let's say 20 hours per week. And important to note that the full-time working hours only apply to persons who are full of age, so not to minors. Minors cannot work that much. And in case of summarized working time, so that means working in shifts, the working hours may of course be distributed differently. So it's not like from Monday to Friday, 8 hours a day, but in shifts. So let's say short week, long week, like in restaurants.
Just this little question, and it's about the minors. We have people leaving high school and entering university. We are talking about this transition. Many people, they start their university at 17. Is there any concern in regards of their internship under an Estonian company, or is there like what place in this matter? Do you have any? Yeah.
Yeah, so the most important thing is because they are a minor, their parent has to give consent that they can actually work. But because they are already 17-year-old, they can work up to 8 hours per day. However, they cannot do overtime work like people who are full age can. So I can also talk about overtime. Because a very important thing is that overtime work must be agreed upon by both parties. We sometimes get questions where people ask that they stayed longer at work, but they didn't notify their employer, and they're curious if they should get extra payment for that or not. But very important to know that the employer cannot force the employee to stay for longer, nor can the employee demand overtime work. It has to be agreed upon. And also, even with overtime work, the daily and weekly rest time rules must be followed, and the working time cannot exceed usually 48 hours in a 7-day period. However, there is the possibility for parties to agree upon longer working time, so that's 52 hours per a period of 7 days, but that agreement cannot be detrimental to the employee, and the employee has the right to cancel such an agreement at any time by notifying the employer 2 weeks in advance. So the employee also has to, both in the latter case, so 52 hours per week, that means that both the employer and the employee really have to pay attention whether such long working hours are somehow damaging the employee and take measures against that.
Yeah, that's really important. And when we are talking about small companies or startups, it's very known that everybody works over hours in this sort of environment. So for the employer, it's very good to state what is correct or not under the law, check again with Labour Inspectorate and see what they can do in regards of contract, but also about, again, the safety and the personal life of those employees in this environment, the mental health and any other consequence that can be affected by a bad contract and terrible working hours, right? So I like to talk to, and I talk very often to many founders. And when I talk about contracts or so, I just say well, let's keep in mind that the employee doesn't have a company, the company is yours. And also do a contract that you would love to have in case you are working for a company that you admire. So do the same for your employee. So that's, I think, the correct standard common sense that we have. So always pay attention to working hours, please, of your employees. And talking about standard numbers here, what is the minimum wage here in Estonia, which global founders should be aware of?
So the minimum wage is set by our government, and they established it for a certain period of time. Usually it's for 1 year. Currently it is, so this year it's 725 euros per month, or 4.30 euros per hour. And that agreement of the minimum wage is concluded between the Employers Confederation and the Central Federation of Trade Unions. So it's an agreement between the employers and the employees. But however, it's important to note that that there is the minimum wage that is established by the government. However, the salary requirement may also arise from the Aliens Act, which applies to those who are from outside the EU or the European Economic Area or Swiss Confederation. There are a lot of differences. What are the grounds for the stay in Estonia, and what are the grounds for working in Estonia? And from those, there are different fields where there are different salary requirements. So if you have questions regarding that, so for people from third countries, it's advisable to turn to the Estonian Police and Border Guard Board, because they have the migration consultants who are experts on that field, which salary requirement is used in each specific case.
So talking about profiles and things here, in the regulations about under Estonian law, the regulations about annual leave, sick leave, and other types of paid time off for employees hired under an Estonian contract.
So the law states that the annual leave for the employee as is at least 28 calendar days. So it's in calendar days, not working days, which is Monday to Friday calendar days. But parties may agree to a longer annual leave. That is very possible and encouraged because people also need to rest. But if so the law states that it's 28 calendar days, but if the employee has been established or to have partial or no workability, or they are a minor, then the annual leave must be at least 35 calendar days. So there are two possibilities for the employee to use their annual leave. So the first option is when the employer draws up a holiday schedule for each calendar year and then communicates it to the employees. And that must happen in the first quarter of the calendar year. And the employer has to take into account all the wishes of the employees. Not all of the wishes, but kind of try to weigh what are the wishes of the employees and what are the possibilities of the company. So in that case, if there is a schedule and if parties wish to amend it, they must come to an agreement. However, if the employer does not create the schedule, the employee just has to notify the employer 14 calendar days in advance that they are going to take time off. And then and that's just like a notification. The employee doesn't have to ask for consent from the employer. But in both cases, the employer can only interrupt or postpone the holiday in case there is a force majeure, so unforeseen substantial emergency, in particular if there's a need to prevent damage. And in that case, they have to compensate the costs that are arising for the employee. So let's say an employee wanted to go on holiday and there is a huge force majeure, and they cannot go on holiday. So then the employer has to reimburse all the expenses that incurred to the employee.
Okay, that's very, very important. But let's go to the other side of the contract now. Let's talk about termination. How does that work here usually in Estonia?
Oh, I also forgot there was a second part of the question, which was about the sick leave and other types. So there's the annual leave, and then there is sick leave. Obviously, when a person is sick and they cannot work, then they must turn to their doctor, and the doctor then issues an electronic sick leave certificate. So when the employee is incapable for work, and then the doctor forwards it to the health insurance fund, and then the employee has to confirm it. So that all happens digitally. The first 3 days of the sick leave are the employee's liability. The employer has to compensate from day 4 to day 8, and the health insurance fund pays compensation from day 9. And other types of paid time off are study leave and all kinds of family leaves. So the study leave is up to 30 calendar days per year. And if the employee wants to complete formal education, then there's additional study leave of 15 calendar days. So let's say if they want to graduate their bachelor's or master's degree or high school. And then there are different types of family leaves. They are usually compensated by the state. So maternity leave, which is up to 100 days, paternity leave, which is up to 30 calendar days. And then both parents have the right to, but only one person at a time can use the parental leave, which is up to the age when the child reaches the age of 3. And then there is adoptive parental leave, child leave, and then child leave for parents of a disabled child, and then carers leave. So they all have some nitty-gritties that I will not go into, but just for information that there are different family leaves as well.
Very interesting. And when we talk about these leaves, especially about the family ones, the dates and time that you mentioned are the ones covered by the state. But in general, they can stay, like the female can stay up to 3 years, as you mentioned, of work. But then you have a different balance between employer, state, and the own person time off and underpayment during the time, right?
Well, actually, also the father can, because it's called parental leave. So also the father can stay home if they wish to. just like only one parent can use it at the time. But yes, the Employment Contracts Act protects parents of young children quite a lot. It's called positive discrimination, because people have obligations for their families as well, and they have to find that work-private life balance. So that's covered by the Employment Contracts Act.
It's so interesting that in Estonia we think about the parents in a equal way, no? The both sides, because in many countries when we see the female, the person who gives birth is a person who stays, I don't know, sometimes 4 months only off work, but then the father or the person who the other parent takes, I don't know, a week off only. No? There are countries that really discriminate the equality between the two parts of what we call parents, right? So in Estonia, it's a bit more equal between both sides, I believe so.
Yes, well, there's like the maternity leave, which is only for the person who is pregnant, but yeah, there's also a paternity leave for the father. But the parental leave itself, yeah, that's either parent can use it.
What are the regulations regarding employee rights, including non-discrimination, harassment, equal opportunities in Estonia, especially now that we see so many foreigners coming to Estonia, including I, coming this wave of foreigners arriving in Estonia finally. So I think that's an interesting question.
So yeah, the Equal Treatment Act and the Gender Equality Act are the basis of the equal treatment. So the purpose is to protect individuals from discrimination on the basis of race, nationality or ethnicity, skin color, religion or beliefs, age, disability, or sexual orientation. However, that list that I aforementioned list that does not limit requirements for non-discrimination in employment relationships. So, for example, as we spoke before about new parents who are still finding like their work-life balance, so though they cannot also be discriminated, exactly, fulfilling family obligations, also social status, language skills, when they're representing the interests of employees or belonging to an employee union. So in employment relationships, there are also other types of characteristics on which the employees cannot be discriminated.
What would you say to employees who do not feel not protected by the law, but hurt by one of these items the topics that we just spoke about? What this employee should do in case they notice that they are feeling harassed or discriminated by any sort?
So the first step is to turn to their employer, preferably in writing. So let's say an email or a text, or they use Skype or Teams or whatever, and ask for a clarification. And, not like accusatory, but to ask for objective reasons why something is happening. Maybe there isn't like discrimination. Maybe there's just some kind of a misunderstanding, or there are some objective reasons. So that's the first step. It's always the aim is that both the employee and the employer can find common ground by themselves, so that they do not need to escalate the situation, but they fix it or come to terms by themselves. However, if the employer doesn't respond, or the response is something that the employee didn't expect, then there's always the right to turn to the Equal Treatment Commissioner. Commissioner for Equal Opportunities, and ask for the verdict. Is this discrimination or not? In regards to termination, there's always everyone has the right to protect their rights if they feel the need to, so they can contest the termination. Which is also an important thing. So let's say your employer fires you for lose of trust, or that you didn't fulfill your work obligations, but if the employee finds that this is not a valid reason, or that shouldn't be grounds for termination. So then they can contest the termination and then turn to either to the court or the labor dispute committee. But we will come to that.
So we were talking here about employees' rights in Estonia, but we also have other sorts of contracts and rights under them. So let's talk about part-time and even fixed-term employees here. What are the regulations associated to this contract? We have spoken a little bit about it, but if you could give us some examples of what you have in regard to this topic.
Yes, so part-time work is totally fine. The law does not limit whether the parties can conclude such contracts or not. So if both parties are okay with part-time work, then it's good. So let's say for students or people who just don't wish to work full-time, so that's perfectly fine. But it's just important that both parties understand what is the working time of the employee. So when full-time is 40 hours per week, so then in the contract there must be set what is the work time. So let's say they're working half time, so 20 hours per week. So that must be really clear in the contract. However, when we are talking about fixed term contracts, then those can only be entered into if it is justified by really good reasons that are allowable in the Employment Contracts Act. So because of the temporary fixed term characteristics of the work. So let's say there's a temporary increase in work or performance of seasonal work. So right now it's summer, a lot of tourist things are happening in Estonia. So then it's okay or let's say in agriculture, it's going to be harvest season soon, I suppose. So then that's fine. Also, when there's a necessity to substitute an employee who is temporarily absent. So we spoke about family leave. So let's say for an employee who is on a parental leave, then in that case, it's okay to sign a contract for fixed term. However, a contract cannot be signed for fixed term just for the reason that both parties wish that to happen. Then that is not applicable. The reason is because the law assumes that employment contracts are entered into unspecified term, then the protection of the employee is guaranteed by the fact that if the employer cannot prove that there is a justifiable reason for the contract to be fixed term, then the contract is deemed to be signed indefinitely from the beginning.
That's so interesting for employees. We see in some countries like France or Germany, they have this tendency of having like fixed contract term for some employees, which is renewed, and sometimes some companies take advantage of it. For the unfortunate side of the employee. So Estonia law protects employee in this matter, which is very interesting again for employers. Now, one thing doesn't take off the other side. So that's something that it's really, really important and very well done here in Estonia. So let's go to the last question then. Sorry, before I wanted to just understand if the part-time and fixed time here in Estonia, or actually the lack of fixed term because we don't have it here, but the part-time one can be also applied to non-EU seasons. How is it?
Well, the difference is whether the payment requirement is met. That's, I think, the question. But however, Employment Contracts Act applies to all employees, so it doesn't matter whether they're Estonian, whether they're from EU, whether they're from third countries. Yeah, there is just a payment criteria that must be taken into account.
Because in this case, we are talking about those employees living in Estonia mostly, right? So this is what we understand. Yeah. So,
yes.
Okay, let's go finally to almost the last question, actually. What are the options for resolving labor disputes here in Estonia or conflicts between employers and employees? We have spoken a little bit about it, but could you talk a bit further about this topic?
Yes, so the first thing is for both parties to, because in employment contracts, the parties have the obligation to be loyal to each other, so that also, and be reasonable. So then that obligation is also applied to conflicts that they must try to solve them on their own first. So whatever the question is, first, come together, talk about it, or exchange emails. If that doesn't work, then there is always the possibility to turn to a labor dispute committee and to ask for a verdict. So who was right, who was wrong, or to have like claims, let's say they're monetary claims. And then there is also the possibility to turn to the court, because Labor Dispute Committee is an extrajudicial body. So it is kind of like the court, but not really. So that's why there is labor dispute committees, because it is faster and it is not as costly as turning to court, so it is more accessible. But there is always the possibility to turn to court to fight for one's rights. And then, if it is about discrimination, for example, then there is always the opportunity to turn to Commissioner for Equal Opportunities, because it is an important topic and it must be talked about more. And also, if there is an actual physical conflict, then obviously the first step is to turn to the police, because that is definitely
that's another escalation. That's again, aside from the physical disputes that I haven't heard about it so far in Estonia, but it might happen somewhere. And we saw some memes on the internet sometimes about people fed up with each other. Now, the very last question. What about those global founders who already live somewhere else with the Estonian company, hiring people from other places, living in another country? Can you let us know a little bit about it and who or what people should be looking for?
So the important thing to note is what country's law applies to that employment contract. So whether it's because it's an Estonian company, then maybe Estonian law should apply, or is it because the employee lives in another country, then the country of their residence as law should apply. So that is an important question, because when there is a dispute, where should the parties turn to? Which country's court should they go? So that is there is the possibility for the parties to agree which country's law applies. But then it is important to note that both parties must be able to protect their rights. So let's say the the employee is living in South America, and they have concluded a contract agreeing that the Estonian law applies, then it must be really hard for the employee to turn to Estonian court or labor dispute body to fight for their rights. So it is really an important topic, because even national holidays, what is the minimum wage? So that is really important. If there isn't an agreement in the contract, let's say, what country's law applies, then usually the country's law that is applied is where usually the employee does their work, even if it's just for a temporary time. So let's say I'm an Estonian employee, but I'm going to go travel abroad, do a grand world tour. But I'm going to stay in one country for the simplicity of the example. So then, because I am living currently in another country, then that country's law applies. Or the second option is that if, let's say, I am traveling everywhere around the world, then the country which's law apply is where I was hired. So because in that example that I just gave, I was working in Estonia before, but then I went traveling, so then Estonian law applies. But it is really a tricky subject, but a very important one.
Definitely. First step is always to do the most of the contract under Estonian regulation, but also protecting the employees wherever they live. Call Labour Inspectorate, because they are going to help you with that. In your case, with your employee, with different perspectives. But also, let's remind that e-Residency has a marketplace you can see on our website, where you can find law officers or consultants from many countries who can help you with this matter as well. So you can not only consult Labour Inspectorate, but complementary, you can have access to lawyers who can help you with hiring these employees in another countries. Aside from that, there are so many companies nowadays that help companies to hire people internationally. We have big names in the market, so they play as an intermediary. So they make it easier, all of the regulations between Estonia in this case and the other country as well. So it's worth to check those companies. But I think we are good right now. Piia Paula, please give us the best contact that employers, founders can reach out to Labour Inspectorate, but also employees where they should find you or how they can contact you or Labour Inspectorate?
First of all, if you want to contact us, then come with a concrete question. That is the most important thing. But how to contact us? Then you can call us. We do speak English most of the time. Right now it's summer holiday, so it might be a bit tricky, but we try our best. So our phone number is 640-6000, or you can also write to us. So it's in Estonian jurist at ti.ee. So it's pretty much lawyer at ti.ee. And there it would be advisable to state in which language you want the response to be. So let's say you want the response to be only in English, then please state that, because otherwise we have to respond both in Estonian and English, and then it's going to take a bit longer for the response to come back to you.
Out of curiosity, for our international audience, are there any consultants that you know that speak Spanish or French or German?
So yeah, one of my colleagues, she speaks Portuguese, but let me think. I think usually, well, I do speak a bit of German, but that's not really a skill that I can boast with, that I can actually like consult in. But yeah, I think Estonian, English, and Russian, those are, and Ukrainian as well. But then we have one unicorn who speaks Portuguese.
Wonderful. Maybe she can speak Portuñol, so she can also cover the Spanish, the Hispanohablantes. Piia Paula, thank you so much for your time. Thank you, Labour Inspectorate, to also now being represented by Piia Paula to come here and speak to our global founders. So important. Thank you so much for your time.
Yes, thank you as well. And if you have any questions, it would be reasonable first to ask us instead of calling us later if you already have a problem.
Always important, right? Okay, thank you very much. And people, bye-bye.